Here we are at part 3 of the 1 to 4 family residential contract, and this will be the final portion of this. Paragraph 13 talks about prorations. A lot of information here: taxes for the current year, interest, maintenance fees, assessments, etc. They'll all be prorated through the closing date. Okay, so the tax proration may be calculated taking into consideration any changes and exemptions. One of the things with this paragraph is that people get confused about adjustments. So what they're saying is, if you close in the middle of the year and something changes, all right, that affected the taxes for the year, what they're agreeing to in this paragraph is that the buyer, all right, the seller actually will be liable for paying his portion that he should have paid had he owned the property all year. It's a little confusing. Now, the problem with that is, sure, try and find the seller after you sold the property and get him to cough up any additional money that he might owe. But it informs both parties that they'll be charged taxes, fees, etc. All right, and talks about rents too. So if there's any monies that were collected as a rental property, okay, that in advance, those would be due the buyer, right, for the remainder of the year after closing. Title company will calculate these prorations and accredit the buyer with the portion owed by seller. So it'll come out of the seller's proceeds, all right? And again, the second sentence states that if their taxes are paid in arrears, meaning end of year, and if there was a change, okay, the buyer and seller will be charged with their portion of unpaid taxes. There's two very good explanations of this. One is the Allegiance title video on prorations, and the other one is a PDF file explanation of prorations. And it should clarify this paragraph. Okay, paragraph 14 talks about what happens if the property is damaged during the contract period. And we know in Texas that's a likelihood, especially with hailstorms affecting a roof, which happens quite a bit. So at that point, the seller can restore the property prior to closing if it was damaged. If they do not, the buyer can terminate or extend the time for the seller to perform, right, for up to 15 days. They have to be notified in writing to do that. All right, it gives the seller time to fix, or they can accept the property with an assignment of the insurance proceeds. You want to be careful here that you're in touch with any insurance agents that are for the seller, so that it's very clear that any monies that will be paid by the insurance adjuster will go to the buyer if that's the case. And then you also have to talk about deductible. All right. So the seller would be liable for the deductible to pay to the buyer if that's applicable. And it says here in the last sentence, if permitted by seller's insurance carrier, and receive the credit from seller at closing in the amount of the deductible under the insurance policy. So the seller would pass over to the buyer the deductible, and the insurance proceeds would be given to the buyer. But you want to make sure that the insurance agent is in the picture and they agree to that. Okay. I would recommend an amendment to the contract would be necessary, and a letter from the insurance company confirming that they will assign the proceeds of the claim to buyer if they have not already been given prior to closing. Okay. Paragraph 15, default. Whoa, this one is a lot of energy expended on trying to figure out exactly what this means. Paragraph 15 is difficult in the sense that people try to understand what is specific performance and how does one enforce specific performance. Well, the definition of specific performance is an equitable remedy in the law of contract, whereby a court issues an order requiring a party to perform a specific act such to complete performance of the contract. So a little vague, but it means that you'd have to get a court order for the seller to be able to do, or the buyer to be able to do something. Now, understand, you can't force either party to sell their house, right? Now, the key word is buyer or seller may choose those options. If the buyer or seller elects to terminate the contract, written notice of termination must be given to the other party. So read that paragraph closely. There's the options. If buyer fails to comply, it tells them what might happen. The seller may enforce specific performance. They can terminate and receive the earnest money. And if seller fails to comply with the contract, the seller will be in default, and buyer may enforce specific performance or seek other such relief as may be provided by law or both, and terminate this contract, receive the earnest money. Probably the most applicable part of this paragraph is if there is a dispute about the disposition of earnest money, and we find that all the time where one party or the other does not want to sign the release of earnest money. Well, then, all right, you could go to court, claim default. One party would be the defaulted party, and then the court would, under the premise of enforcing specific performance, force the earnest money to be distributed to whichever party is in the right. Okay. And again, disposition of the earnest money is governed by, release of earnest money form TAR 1904, and it releases everybody from any other liability and decides who would get the earnest money funds. And again, if either party refuses to sign, a court order would have to be acquired in order for the title company to release the funds. There we have specific performance. Paragraph 16 states that mediation should be invoked to resolve disputes between parties. Mediation is a non-binding decision by a third party. Okay. Mediation is different from arbitration. Mediation does not have the force of law. It's an objective third party who says, well, party A is right or party B is right. All right. Now, they can either say, all right, fine, we take your word for it and we'll settle. They don't have to do that. All right. Now, arbitration, on the other hand, if you go to arbitration, it has the force of law. Arbitration is done in a legal, semi-legal process where somebody says party A is correct. Well, that's the rule of law. Now, if the other party doesn't comply, the party can then get a judgment against them if it was settled by arbitration. That is not the case with mediation. Okay? But the intent of this paragraph is to provide a structured opportunity for the parties to air and resolve their grievances before resorting to remedies at the courthouse. All right, this used to be an optional election on the TREC form, no longer. In other words, this is where they want you to start the fight. Okay. The last sentence states that you can go right to court, but most likely a judge will advise you to do mediation or arbitration first. They don't want to clog the courts with these petty disputes. All right, they want you to take it off of the court calendar and do it via mediation or arbitration. Paragraph 17 informs the parties that if a legal proceeding is necessary to resolve a contractual issue, the winning parties are entitled to recover their costs for attorney fees and the costs of initiating the procedure. Paragraph 18 is lawyer words to inform parties that title company has no liability under the contract, no liability for interest on held money or liability for loss of earnest money. So it's something that was put in there to make sure the title company has no blame for just about anything. Paragraph 18b talks about how the title company will apply the earnest money at closing, first to the down payment and then to expenses. Now, if no closing occurs, unless the termination is done during the option period, most title companies will not release the earnest money without the form signed by both parties. They only do it in a cut and dried situation, which is paragraph 23, okay, when you have an option period and it's obvious to the title company that the contract was terminated during that option period, okay? Anything other than that, forget about the title company releasing earnest money without that form signed by both parties. Now, it states further that if the title company paid for items on behalf of one or both parties, they are entitled to deduct that expense from the earnest money prior to release. An example might be if they paid for a survey to be done and contract terminated. Now, this is rare these days. Years ago, it used to be that the title company would pony up the money to do surveys, to do a couple of other things, okay, and then figure that they're going to get paid at closing. Well, I think they got burnt one too many times where they, owed a lot of money out in survey costs, which they didn't recoup. So they will pretty much have those things paid, what they call POC, paid outside of closing. If you need to do a survey, if one or other party is required to do a survey, they'll want the money up front. Okay, so they know that they're going to get paid. Paragraph 18C, demand, having to do with earnest money. Okay, the contract is somewhat clear on this. Upon failure of the contract for any reason, the party desiring the earnest money must make written demand upon the title company. Now, a written demand should be exactly that, an email, a letter, or whatever. Some agents confuse the fact of sending a release of earnest money to the title company as demand. That does not really satisfy because a copy of the demand should be sent to the other party. So I would suggest that if you are an aggrieved party or you represent an aggrieved party, okay, you send a written demand referencing paragraph 18C and accompany that with the release of earnest money to the other party and copy the title company. Okay, the written demand triggers a 15-day window during which the other party may make objections to the title company. All right, now email or text might be sufficient. Texas recognizes that type of communication. But certified mail to both title company and the other party is always best, all right, particularly if it could wind up in litigation. Now, a good explanation of the title company's explanation of paragraph 18C is on the link there. One of the problems with the demand is that the time comes and goes for the person to make a decision on, from withholding the earnest money, okay, usually in spite. They don't want to give up the money. Now, here's the deal. The title company, from experience, will still not release the earnest money after 15 days, okay, which the paragraph kind of leads you to believe that if you follow the rules and you do everything according to what the paragraph says, you'll have the earnest money. That's not the case. Title companies are risk averse. So unless the release of earnest money is signed or a court order, all right, is done, you can pretty much forget about getting the earnest money unless that form is signed by both parties. Okay, paragraph 18D talks about what might happen if one party or the other refuses to sign the release of earnest money when they are in the wrong and are just doing it out of spite. All right, they talk about any party who wrongfully fails or refuses to sign the release within 7 days of the receipt of the request will be liable to the other party for damages, the earnest money, reasonable attorney's fees, and all costs of the suit. They put that in there for exactly that reason, to try and stop people from arbitrarily, even when they know they're in the wrong, from releasing the earnest money, thinking, well, if I wait long enough, the other party will just give up. It's not the case. Paragraph 18E establishes the time frames for the demand and the response. Now, again, a legal view of paragraph 18C and E is included, which is the same link that was on the prior slide. Paragraph 19, the seller promises that everything agreed to in this contract will be resolved by closing. So in other words, there's nothing left to accomplish, hopefully. Example, the seller doesn't disclose a lien. Maybe he had a separate side deal with somebody about a lien on the property. The title company couldn't find it. After closing, it pops up, thinking that it is closed and their responsibilities are over. They're not, and the buyer can go after the seller legally at that point. Now, if title company makes their own mistake about not discovering that there was a lien on the property that had been filed, and I've seen that happen, where title company has overlooked for one reason or another a second loan on the property, and it pops up afterwards, and the lender is claiming or threatening foreclosure. That's what the title policy is for. The title company would be responsible for paying that note. Right? So there's two issues there. What they're talking about here is that these are the things that ordinarily wouldn't be found out in a title search. Separate agreements, side agreements that haven't been disclosed. This paragraph also states that the seller can continue to show the property and receive backup offers even while property is under contract. We do find agents from time to time that say, oh, well, we have a contract on the property. Why do you still have it active or active contingent or whatever, on there? Well, seller can do whatever he wants because right up until the time of closing, he can accept backup contracts. Paragraph 20 informs the parties of the obligation of the buyer to withhold taxes from the proceeds of a foreign seller. This paragraph is a little misleading because typically, even though it is the buyer's responsibility, the title company will usually handle the process. In other words, they'll create the forms, withhold the money, and I saw recently that this happened, and they actually sent the money to the taxing authority, the IRS. You need to, if you have a foreign person that you're dealing with, either from, as a seller, you should probably keep in contact with the title company as to how they're going to handle it. Because remember, the requirement is that the buyer collects the money, all right, and sends it to the IRS. You really don't want to get into that if you can avoid it. So find out what the title company will provide for you. Okay, and again, another Allegiance title video on that particular paragraph. Paragraph 21. Throughout the contract, there were several instances in which notices are required to be delivered. Well, delivered where? Well, here's where both buyer and seller officially state where they can be reached at. Right? Most agents leave this blank, and that is a big mistake, leaving that blank. All right? Because then you're putting yourself in a situation as an agent, right, that you are going to accept all these notices and documents. Right? And I'm sorry, if you're not paying attention or you're on vacation and somebody sends you a notice that has a timeline attached to it, you're responsible. Okay, so get in the habit of putting your client's information here, not yours as an agent, or you could be liable for consequences. And again, another good video on paragraph 21. Paragraph 22 states that an amendment should be used to change anything on the contract. Once a contract is signed by both parties, all right, don't go back and start scratching things out and putting new information in there. That's what an amendment is for. And the reason that we say not to do that is because some of the things that you might change have timeline requirements to them. And guess what? If you change something and then have both parties initial it, the original timeline still prevails, right? You could change a number of dates or something like that. So you could cause a major problem in the contract by going in there and changing something on the original contract. All right? Use an amendment. It also identifies the most common addenda and forms attached to a contract. Check, appropriate boxes that apply that are being attached to the contract. There's also another box there that allows you to free-form any other addendum or notice that you want to include. Paragraph 23, termination option. What we commonly termination option period is a good way of expressing it. Option period is invoked to allow buyer time to do inspections on the property and gives buyer the unrestricted right to cancel the contract during that period. If the buyer does not want to buy, and that's a good choice of words, buy the option, all right, then I strongly suggest that not only do you put in here not applicable or leave it blank, but also there's another homemade form that that states I elect not to do an inspection. I mean, certainly a buyer can do an inspection without an option period, but why would he do that? Because if the inspection, it turned out that it showed deficiencies in the property, he doesn't have a leg to stand on in terms of terminating the contract. He's going to rely on the good graces of the seller to fix those things, but the seller's under no obligation to do so. Now, paragraph 23 also addresses that the buyer is purchasing the option from the seller, so hence he must pay seller something. That amount cannot be zero and should be something of value, as in $10 or more. And you would also specify the number of days requested for that option period. Now, as an aside, there's also on an amendment the ability to extend the option period. And again, cannot be zero. All right, you must have some kind of value in here because you're purchasing. It is a transaction where you're paying money for the right to terminate. All right, so there's got to be an exchange of something of value. Option money must be delivered to the seller or the seller's agent within 3 days of contract execution date. Contract execution date is day 0. So if the contract execution date was on a Monday, the 3-day window would be Tuesday, Wednesday, and Thursday to deliver the option money to to the other party. If buyer elects to terminate, notice must be given by 5 p.m. by the date specified in the option period. If the buyer terminates properly, the earnest money will be refunded to buyer, but the seller keeps the option money. Now, one of the things that it used to be in the contract was that, and it caused a lot of grief, was that they used to have the notice of termination all the way up to the end of the day. So a lot of agents would send somebody a notice of termination on the last day of the option period at 11:59 or just before midnight. Well, that caused all sorts of havoc because, who's paying attention at 2 minutes to 12 at night that the person is terminating? And, there would be arguments back and forth. Well, I didn't receive it, it wasn't sent, etc. So that's why they moved this back to 5 p.m., which is a reasonable amount of time to give notice if the buyer is going to terminate the contract. So if there was a 5-day window in the paragraph there, say he paid $100 for 5 days, all right, well, he's going to have day 0 is a contract execution date, might be a Monday. He's going to have Tuesday, Wednesday, Thursday, Friday, and Saturday when the option period is over. Okay? Standard practice is that the option fee will be credited back to buyer at closing, so that first checkbox. But it's all negotiable. It can be done either way. And notice the last sentence in bold. The time is of the essence, which means strict adherence and compliance to the time frames is necessary for this particular paragraph. Paragraph 24 informs that if either party is represented by an attorney in the transaction, that attorney's information must be identified. Any notices or other documents will be copied to that attorney. Last item on the contract is the execution date. Right? By signing the form, meaning the contract and the addendum, the parties have instructed the broker to fill in the final date of acceptance as the effective date. The final date of acceptance is the date on which the contract becomes binding between the parties. It is the date that both buyer and seller have agreed to all terms of the contract and have executed the contract. So 4 elements must be satisfied for final acceptance. Now, typically we know that, a buyer fills in an offer, sends it to the seller, They may go back and forth, they may not in terms of changing things. But let's say they don't. Okay, well, the final contract must be in writing, no problem. The buyer and seller must sign the final contract, including the initialing of any handwritten changes to the initially drafted offer, if applicable. Acceptance must be unequivocal, no hooks, okay? They accept it as it is. The last party to accept must communicate acceptance back to the other party or the other party's agent, if applicable. So, let's say that you sent in an offer, and the seller didn't like the offer, okay? So he crossed out the amount of cash and the amount, let's say it was a cash offer. So the amount of cash and the final offer price, and he raised it by $5,000, all right? And then he initialed that, okay, and signed all the other documents. Sends it back to the other party, okay, who is now the buyer. Well, there's no executed contract yet. The buyer has to initial those changes, all right? And at that point, that is the contract execution date. So the effective date is a date when the last element communicating acceptance back is made after the other three elements are satisfied. Now, that also means that if the buyer is initialing a change that the seller made, says, okay, I'll agree to the extra $5,000. The contract execution date is the date that he sends that acceptance back to the seller. Okay, if you wait overnight before sending it back, then and agents do make this mistake. They may initial it, okay, but they don't send it back to the next day. Well, the next day is the contract execution date, all right, because in order to satisfy the elements of this, it has to be given back, right, to the other party as communication of acceptance. Right? As usual, if you have any questions, give us a call, or if you want to look at additional videos, there's the link to look at other addendum and other portions of the contract. Thanks.